In the last episode, we talked about Brown Nose Day, a trademark dispute with an irresistible name, but a very serious lesson. Red Nose Limited believed Brown Nose Day was too close to its family of Nose Day trademarks. But the challenge arose after Brown Nose had already been registered. Red Nose asked the Registrar of Trade Marks to use a special power to revoke the registration. The full federal court ultimately confirmed that Brown Nose Day should remain registered and made an important point. The registrar's revocation power is exceptional. It is not a substitute for filing an opposition at the proper time. Or, to put it less formally, once a questionable trademark has slipped past you and made itself at home on the register, it can be much harder to remove the smell. That raises the practical question I want to answer in today's episode. How do you know when someone applies for or starts using a brand that's too close to yours? Because registering a trademark does not put IP Australia on permanent patrol for your business. It does not mean someone will call you whenever a competitor adopts a similar name. And it certainly does not mean infringement will be automatically found and stopped. A trademark registration gives you a legal right. Monitoring is how you find out when you may need to use it. Welcome back to Elise Explains IP, the podcast where we make intellectual property practical, strategic, and where possible, slightly less painful. Today, I'm talking about trademark monitoring. What is it? What you should be watching? How the IP Australia opposition process works? And what your options are when you find something concerning. As always, this episode is general information rather than legal advice for your particular circumstances. Registration is not a monitoring service. Let's start with that common misunderstanding. When IP Australia examines a new trademark application, the examiner searches the register and may raise earlier marks that appear too similar. That is an important filter, but it is not a complete brand protection service for existing owners. An examiner works within the Trademarks Act, the register, and the application in front of them. They may not know that a new applicant has copied your packaging, approached your customers, adopted a similar domain name, or chosen a name with a particular reputation in your market. They may accept an application that you believe should not proceed. Acceptance doesn't mean that IP Australia has ruled conclusively that the trademark or the applicant is entitled to registration. It means that the application has passed through examination and is now advertised so that third parties, including you, have an opportunity to oppose it. That opposition window is where a monitoring service becomes critical. There is also a second gap, that not every infringer files a trademark application. Some businesses, many businesses, simply begin trading. They launch a website, open a social media account, list products on a marketplace, or put confusing branding on a shopfront. If they never apply to register the name or the brand, monitoring the trademark register alone will not find them. So an effective monitoring system needs two lenses. The first watches new trademark applications. The second watches what is actually happening in the market. What should a business monitor? Imagine you own a registered trademark for a skincare brand called Glow Theory. You might understandably watch for an application for the exact words, Glow Theory, but that is only the most obvious risk. You may also need to watch for variations, such as GLO Glow Theory, Glow Theories, or The Glow Theory. Depending on the circumstances, a mark might be concerning because it looks similar, or it sounds similar, or it creates a similar overall impression to your brand. You should also consider whether the risk sits outside the precise class in which you registered your trademark. A skincare brand might be registered for cosmetics, but confusion could arise through closely related retail services, beauty treatments, online stores, or products that consumers would expect to come from the same business. Logos matter too. A competitor may use different words, but copy a distinctive device, a mascot, a colour arrangement, or a visual feature. And then there are the places where a conflicting brand may appear before it reaches your radar. Places such as the Australian Trademarks Register, Google and other search engines, domain name registrations and new websites, social media usernames, pages and paid advertisements, online marketplaces such as Amazon, eBay or Etsy, app stores, ASIC business and company name records, industry directories, trade shows, and local advertising, distributor, retailer and customer feedback, and of course overseas trademark registers, if you currently trade or are planning to trade internationally. ASIC deserves a quick clarification here. Registering a business name is not the same as owning a registered trademark. ASIC generally does not determine whether a business name infringes someone else's trademark. But business name records can still be a useful early warning that someone is moving into the market under a similar name. The same applies to domain names and social media handles. Securing the handle does not create a general legal right to the brand, but watching those channels may reveal a problem while it is still small. There are different levels of monitoring, and the right level depends on the value of the brand, the likelihood of copying, the size of the market, and the countries in which the business operates. At the simplest level, a business can schedule a regular search of the Australian Trademark Register using the publicly available search database. They could search exact marks, but also sensible variations, misspellings, phonetic equivalents, or important elements of a logo. You can also create search engine alerts for your brand name and key variations. Those alerts are not always perfect, but they may detect new websites, articles, product listings, or public pages. Social media and marketplace searches can be added to a monthly or quarterly brand check. Businesses with a large product range may use marketplace monitoring or image recognition tools to identify suspicious listings, copied photographs, or counterfeit goods. As we have already mentioned in our previous episode with Marcus Schmidt, there are some great tools out there that you should probably have a look at. A more structured option is a professional trademark watching service. These services monitor new applications or newly accepted applications and report marks that match an agreed criteria. The watch might cover Australia only, selected countries, or a broader international portfolio. It can also be tailored by classes, industries, and the degree of similarity. The advantage is not simply automation. A useful watch is designed broadly enough to find meaningful risk without producing so much noise that everybody stops reading the reports and does nothing with them. That last point matters. A monitoring system that generates 200 irrelevant alerts each week is not really a system. It's an electronic guilt pile. But someone also needs to be responsible for reviewing the results and escalating them quickly. It might be the business owner, your brand manager, the marketing team, if you have one, or an external advisor. What matters is that the task belongs to somebody, a named somebody, and that the deadlines are recorded. So let's say your monitoring works. You receive an alert that Glow Theory has been accepted for skincare and beauty retail services. You are concerned that customers will assume that it is connected with or is selling your Glow Theory products. What happens next? Once IP Australia accepts a trademark application, the acceptance is advertised. A person who wishes to oppose generally needs to file a notice of intention to oppose within 2 months of the acceptance being advertised. That deadline is pretty short, it's strict, and it's easy to miss if no one is watching. Let's have a conversation about Hungry Jack's and Big Mac and why was McDonald's not watching. But that's a story for another episode. The notice is the first step. The opponent must then file a statement of grounds and particulars, which details what their notice of intention to oppose and what grounds they're intending to oppose on. So it identifies the legal grounds relied upon, any sort of material facts supporting them. It's not enough to just say, I don't like this mark, or it feels too close. Maybe the vibe is too close. The opposition needs to fit within the grounds available for rejection under the Trademarks Act or under the other legislation. Depending on those facts, those grounds may include that the mark is substantially identical with or deceptively similar to an earlier trademark for the same or similar goods and services. Perhaps that the applicant is not the true owner of the mark, or that the applicant does not intend to use the mark. Perhaps the application was not made in good faith or was made in bad faith, or that the opponent's mark, being your mark, has acquired such a big reputation and that the new mark would be likely to deceive or to cause confusion. Not every ground will apply, and pleading every possible objection is not necessarily strategic. It's also going to be increasingly expensive. The ground should reflect the actual evidence and the commercial issue. The applicant has an opportunity to defend their application. For a trademark opposition, it generally has a short period after being notified to file a notice of intention to defend. If it doesn't do so, the application will lapse and that will be the end of it. But if the application is defended, then a matter moves into evidence stages. The opponent files evidence support, the applicant may file evidence in answer, the opponent may file evidence in reply, evidence goes back and forth, and it might address earlier use, reputation, sales, advertising, customer recognition, the way the parties trade, and the circumstances surrounding the application. There can be a lot of evidence, volumes and volumes of it. Once that's been assessed, the dispute may then be determined after a hearing or submissions to an IP Australia hearing officer. The hearing officer decides whether the opposition succeeds or whether the application should proceed. Costs may also be awarded, although the scale of costs before IP Australia is very small and will not reimburse everything a party has spent, particularly not on those volumes and volumes of evidence. Oppositions can also settle. The parties might negotiate amendments to the goods and services, restrictions on how a mark will be used, perhaps a coexistence agreement, or a change of brand, or withdrawal of the application or opposition. But settlement should not be assumed. Before filing a trademark opposition, it's worth assessing the strength of your case, the evidence that you have available, the commercial importance of the conflict, and the likely cost. Most importantly, an opposition is about whether the other party's trademark application should be registered. It is not automatically a claim for damages, and it doesn't by itself stop every form of use in the marketplace. That distinction is essential. An application is not the same as infringement. People often use opposition or infringement as though they were interchangeable, but they are not. An opposition challenges an application before it becomes registered, before IP Australia, before the Trademarks Office. Trademark infringement generally concerns unauthorised use of a sign as a trademark in relation to the goods and services covered by a registered mark, or sufficiently related goods or services where those relevant legal tests are met. A business may need to oppose an application even before the other party has launched. Conversely, a business might be infringing your rights without ever filing an application. Sometimes both problems exist at once. The other party may have applied for the mark and already started trading. In that situation, opposing the application may protect the register, but a separate enforcement strategy needs to deal with the actual use. So, what can you do when you detect a possible infringement? The first step is usually not to send an angry email at 11:47 p.m. It is to preserve evidence and investigate. Take some dated screenshots, save product listings, advertisements and packaging. Record where the goods or services are being offered, when the use appears to have started, and whether customers have shown signs of confusion. If someone picks up the phone and asks you if you're this other business, you can keep a note of it. Buy a sample if that's appropriate and lawful. Keep the packaging and your transaction records. Then, assess the facts carefully. Who is using the mark? Are they actually trading, or have you found an abandoned page? Are the goods and services the same or related to what you have protected? Are they using the words descriptively or as a badge of origin? Who used the mark first? What does your registration cover? Are there vulnerabilities in your own registration, such as non-use? That investigation matters because not every similar name is an infringement. Trademark rights are powerful, but they are not ownership of the word in every context and in every industry. Once the position is understood, options may include pursuing an opposition at IP Australia, perhaps making an informal approach to clarify what is happening, sending a carefully drafted letter of demand, which might be seeking undertakings that the other party stop using the mark, remove listings, maybe transfer the domain name or change its branding. You could negotiate an agreement or a license or a staged rebrand. You could report the listing to whatever platform's intellectual property complaint process, or make a domain name complaint under an applicable dispute resolution policy. And, as I mentioned earlier, filing an opposition or a non-use removal application at IP Australia. You can also notice an objection with the Australian Border Force, where counterfeit imported goods are of concern, but you have to have a registered trademark for that. And you can ultimately commence court proceedings, and in urgent cases, you could consider interlocutory relief. Depending on the conduct, you might also be looking at passing off, or the Australian consumer law might be relevant, particularly where there are misleading representations or you have a particularly established reputation. The strongest response is not always the most aggressive response. A small local operator who has innocently adopted a similar name may require a different strategy from an organised counterfeiter importing thousands of products. The objective is to protect the brand and the business, not to create expensive litigation for its own sake. Although us lawyers would love you to create expensive litigation. Please do knock yourself out. There is also a risk of making unjustified threats of trademark infringement. So before accusing someone publicly or demanding immediate action, get some advice on the scope and strength of your own rights. Consistency matters, but consistency does not mean treating every case identically. It means applying a clear decision-making process and keeping a record of why an action was or was not taken. For most growing businesses, a sensible plan can be built around 5 steps. First, identify the trademarks that matter most to you. This may include your core business name, flagship products, logos, taglines, and your distinctive packaging. Second, record what is protected and where. Keep a simple register showing the owner, application or registration number, countries, goods and services, renewal dates, and any sort of licenses you've granted. Again, making sure that that owner is the person who's actually using the brand or the mark. Third, select a monitoring channel that reflects your actual risk. At a minimum, consider the trademarks register, search engines, domain names, and the online platforms where your customers buy or discover your products. Fourth, allocate responsibility. Decide who reviews alerts, how often searches are performed, and who receives an urgent escalation, bearing in mind that a trademark is only open for opposition for 2 months from the day that it is published. And fifth, create a response framework. Preserve that evidence, assess the legal and commercial risk, obtain advice where necessary, and choose a proportionate response. For a small professional services firm, quarterly broad checks and a regular trademark watch for the core brand may be enough. For a busy consumer brand selling through multiple marketplaces, the system may need to be much more active, particularly if counterfeiting, copycat packaging, or unauthorised overseas sellers are a recurring risk. The monitoring should grow with the value and the exposure of the brand. The brown nose case is memorable because of the name, but its practical lesson is also about timing. Red Nose Limited tried to use the registrar's post-registration revocation power. The full federal court confirmed that this power operates only in limited circumstances, and it's not a second opposition process. By the time a conflicting mark is registered, the available pathways will be narrower, slower, and more expensive. So, do not treat registration as the end of the trademark process. Registration gives you the right. Monitoring gives you the opportunity to protect it at the right time. You do not need to watch every corner of the internet every day, but you do need a system that matches the value of your brand, covers both new applications and real-world use, and puts alerts in front of someone who can act on the information before the deadline disappears. If you are not sure what should be monitored, or whether a new application is close enough to justify an opposition, or how to respond to a possible infringement, you can book a strategy call with me via my website. You can also look at my IP audit tool, which is available for free, no sign up, to assess what you have already protected in your business. But we can look at the rights that you do have, the risks that matter, and a proportionate plan for protecting the brand that you are building. Thanks for listening to Elise Explains IP. If you found this episode useful, please follow the podcast and share it with a business owner who has registered a trademark and thinks that the job is finished. Because when it comes to brand protection, keeping your nose out of other people's business is not always the best strategy. And I'll see you next time. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.